do the court cry. All right, we are live and recording. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. Welcome to the July 15th, 2021 sitting of the Massachusetts Appeals Court, courtesy of our ability to appear on Zoom. We will have 4 cases for argument this morning. One of our cases has been continued and one case is being submitted on the briefs. So we will not be taking our morning break. I think we'll try to go through. While we are on Zoom, everything else is the same. So we will have 15 minutes per side, and where we have more than one party, the attorneys will be splitting their time, and we'll discuss that at the beginning. I'm now going to call the first case, which is 2019-P-1497, Commonwealth versus Juvenile 1, and there's a second juvenile. And as I mentioned to the attorneys just a moment ago before we went live, sometimes you will see the judges looking off to the side, and that's because we have our notes and the briefs on other screens, and we want to refer to them during the argument. As we always tell counsel when we are live in person, we've read your materials, we're very familiar with them. Your time is yours to use as you wish. I'd encourage you to get to the heart of your matter. So with that, we have a time split this morning. Attorney Celli will argue for 10 minutes and Attorney Salter for 5, and we'll get the clock up. And when that happens, Attorney Celli, please proceed.
Good morning, Your Honors. Melissa Celli for Juvenile 1 in this matter. As you noted, Justice Henry, the juveniles will be splitting this time in this argument. I will be taking the majority of the time to discuss the shared issue in this case, which is whether the Commonwealth was required to, and whether the Commonwealth did, show that the juveniles were in lawful custody at the time that they allegedly escaped. Attorney Salter will take the last 5 minutes of argument to address any lingering questions and to address any issues specific to her client. This case presents one issue. Does the escape statute for juveniles require the Commonwealth to prove that a juvenile is lawfully detained? And if so, did the Commonwealth prove that here? There is no right more fundamental than the right of the people to be secure from unreasonable searches and seizures. And there is no seizure less reasonable than unlawful detention in a prison, or in this case, a juvenile detention center. That right is what's at the heart of this case. As one court has noted, the lawfulness of the detention is the very gist of the crime of criminal escape, and the commitment by lawful authority is the very essence of the lawfulness of that detention. That is what is at stake here. And it is not as though on the other side, the juveniles are asking that an unreasonable burden be placed on the Commonwealth here.
Let me ask, do you read the Commonwealth's brief as contesting that the Commonwealth needs to prove that they were in the lawful custody of DYS?
I read the Commonwealth's brief as having a 2-prong argument. First, that it did not need to prove lawfulness of custody, and second, that it did prove the lawfulness of custody. And the Juvenile 1 argues that the Commonwealth does need to prove lawfulness of custody, and also that they did not. I will say that even at the jury charge in this case, the lawfulness of custody was listed as an element of the crime that needed to be proven. So it, to my mind, should not be at issue. This shouldn't be an issue, but I think it was a live issue.
But do you think that the judge instructed the jury that they needed to find lawful custody?
The judge did in the jury instruction, that was listed as one of the elements of the crime. However, the judge then also incorrectly noted that you have heard testimony that these juveniles were lawfully detained. And I think that this really is the heart of the problem. What the Commonwealth needs to show in order to show this lawful detention. Here, really, all it would have taken was a 10-minute recess for the Commonwealth to walk to the clerk's office and ask the clerk whether there was a certified docket. And I don't know whether there was, because that's not my case. It wasn't my case, and it is also not my burden. But if he was lawfully detained, all it would have taken was a 10-minute recess to prove as much.
Would anything less than the minimus or analogous order that issues in a juvenile case, I'm not sure, suffice as evidence? What if the Mr. Olson, I guess it was, had testified, I know they were lawfully in DYS custody because I have copies of the minimuses right here, and here's what they say.
I mean, I would argue that coming from Mr. Olson, that is still hearsay, and the better practice would be to have a certified copy of the docket, which frankly, the court could take judicial notice of, I think, but they didn't. And
well, better practice or requirement?
Again, I think that I would say it's a requirement. I think that there's no legitimate reason why that could not happen. It is just the very lowest bar possible. And the fact that the Commonwealth elected not to do that, I don't know what to read into that, but instead, and indeed what they got was not even a statement by Mr. Olson that these juveniles were in lawful custody. That was not even the statement that he made. In fact, what he said was the juveniles in this case were, quote, in the custody of the Department of Youth Service through some sort of legal process.
Well, couldn't a jury reasonably infer from that statement, assuming that it were admissible, that they were lawfully in the custody of DYS?
I don't think they could. I think that saying that that some sort of legal process is tantamount to lawful custody, I think is a bridge too far. I do not think that that is a reasonable inference.
Wasn't that language specifically negotiated, and the parties agreed to use that language to avoid specific prejudice to the juveniles? That
could very well have been. However, that does not relieve the Commonwealth of its burden. The question for the Commonwealth is, the question is, have they shown that these individuals were in lawful custody? And in fact, yes, perhaps they did specifically negotiate on this through some sort of legal process language, but that is not the same as saying that they were in lawful custody. And in fact, the district attorney could easily have framed her question as saying, were these individuals in lawful custody? Well, then I would be, my first argument that is a facially insufficient statement would probably not work. I do think that this is a facially insufficient statement. Then the next question is whether it's hearsay. And, I think that clearly it is. He is, Justice Sachs, you asked whether anything else could suffice. Yes, I could contemplate other things that could suffice. What if they had the attorney who was present at the time of sentencing testify that he was sentenced? What if they had a judge testify?
Why wouldn't that be hearsay?
Because they were there. They were percipient witnesses to the actual sentencing.
Okay, but what could the attorney say other than, I heard the judge say to the juvenile, you're remanded to DYS custody for a while. So why isn't that hearsay?
Well, perhaps, maybe having the attorney is not sufficient. Maybe we would need to have the judge come in. The point is, I can contemplate other things that perhaps would have been sufficient, but certainly the easiest, and indeed, as I said, a very low bar, would be to get a certified copy of the docket.
So the Commonwealth, though, they argue that you did not preserve a hearsay objection, that the objection really was a lack of foundation, not hearsay. What do you say to that?
I would say that this was the biggest issue at trial. This issue
well, that may be, but the objection on the record seems to be lack of foundation.
I have to confess that I don't have every single objection sitting in front of me right at this moment, But in my brief, I cited to several different objections that were lodged to this line of questioning. Let's
assume that none of them were to this point, and so you're up against a substantial risk standard. What do you do then?
I think that this is certainly a substantial risk of miscarriage of justice. If they had only one hearsay piece of evidence proving that they were in lawful custody, a piece of evidence that ought not to have been admitted, that is the only thing here. If they didn't have that, then there would be no way to prove. Of course, that is a substantial risk of miscarriage of justice. And in fact, it was the Commonwealth characterized the remainder of my brief as raising other issues. That's not exactly what I did. I did not raise an issue of an improper closing argument. However, the closing argument of the Commonwealth does go to show the prejudice of this particular testimony. The Commonwealth relied on this improper testimony in proving this one point. The judge relied on this improper testimony when she said, you've heard mention that the juveniles were in the custody of the Department of Youth Services, or DYS. And in fact, this is the one question asked by the jury. The jury asked, can you define a revocation versus detention for DYS? That shows just how troubled the jury was by this very point. And
maybe it just shows.
Go ahead, Judge Singh.
Maybe it shows that those terms were used and never defined. It doesn't necessarily go to the question of lawful detention.
I think that it's a reasonable inference that it did go to the issue of a revocation unit really doesn't have any independent relevance to the case other than to show lawfulness of custody. I can't think of what else they could have been concerned with other than whether this was lawful custody. And I see that my time is nearly out. I'm happy to answer any other questions. Thank you, Your Honor.
Thank you. We'll hear from Attorney Salter. You have to unmute yourself. That's okay. It's probably the most common phrase of 2020 and 2021.
Good morning. May it please the court. My name is Leslie Salter. I represent Juvenile 2 in this case. And I would just echo Attorney Sully's argument and reiterate that the determination of lawful custody was not made out by the Commonwealth. And the issue is of heightened importance with the juvenile case due to the fact that juveniles often cannot advocate for themselves as an adult would be.
That's exactly actually what I wanted to ask you, was that juveniles are different from adults. Somebody is responsible for them. So if this person gets on the witness stand and says DYS is responsible for them, then why is that not enough? Because they can't be out by themselves unless they're emancipated.
Yeah. Well, I think the issue is just that. We don't know in this particular case what the alleged lawful process was and what brought these children to DYS. But
that's what I'm saying. For minors, why does that matter? They were housed in a facility. They had a bedroom. They had a person who said they weren't allowed to leave, and we have a contract with DYS. What the particular terms of the contract are don't matter. But they're like Attorney Celli said, the person's like, this is my job. I know this is my job. They're here. They're supposed to be here. They can't leave. Why is that not enough?
Because without some sort of evidence or knowledge of what brought the child there, it would not be possible, in my humble opinion, to determine whether that placement was lawful. And the reason I feel that the lawful standard needs to be met here is with regard to juvenile justice, especially in the recent years, we've realized that juveniles are in a special place through the legal process and therefore have additional protections. So certainly, even though the statute that we're dealing with is an older statute, I believe it was written sometime in the 1940s, it was written at a time when juveniles did not have the same due process rights as adults as seen by the courts. That didn't come out until, I want to say, if I'm remembering correctly, sometime in the 1970s or early 80s. So you're dealing with a statute that...
May I ask you a hypothetical? What if the parents of each of these juveniles had said, kids, you need to straighten out, and we need to show you what's going to happen to you if you don't. So we have a friend, Mr. Olson, who runs the Old Colony Y, and we're going to have you go over and sleep a few nights in a DYS facility just to see what it's like. Because if you don't straighten out, then you're going to find yourself confined there for a long time. Would they be in DYS custody under those circumstances, or would they still be in the parents' custody, or what would they be?
They would be in the parents' custody, placed at DYS. So this is one of the things that happens in juvenile court. And, I'm sorry, I don't know Your Honor's background, but a child can be legally in the custody of, let's say, DCF and placed any number of places, right, including at home with their parents, but they remain in the custody of DCF. So that's why this is of heightened importance in a juvenile case.
So their physical location is not determinative of legal custody. It's like in a divorce, physical custody versus legal custody.
Correct. So
but if you had a youth that was in the legal custody of DCF, but they had placed them in a DYS facility and the person left, one might say escaped, then you think that they could not be charged under the statute?
I would argue that they couldn't be, because they were not in the legal custody of DYS. They were placed there for, in this particular hypothetical, an unknown reason. Maybe they just needed a bed for that night. Maybe they were placed in the custody.
We don't terminate people's parental rights when their youth is in DYS facility. They're still the legal parents, right? It's that DYS has some sort of lawful custody of them.
Well, that's the question here, right? Is whether DYS did actually have that legal custody of them, or whether they were in the custody of perhaps another facility or another state agency, or even their parents. Without that being specifically made out by the Commonwealth, and again, I would argue that it's of heightened importance in a juvenile case, the Commonwealth cannot meet its burden with regard to this statute. If there are no further questions, I'll rest on my brief.
Seeing no further questions, I think we'll hear from Attorney Anderson for the Commonwealth.
Thank you, Your Honor.
Good morning, Your Honors. Audrey Anderson for the Commonwealth. If it pleases the court, I would first like to alert the court's attention to an error that I made in my brief on pages 9 and pages 16. I said that the juvenile objected to the testimony of Mr. Olson that the juveniles were in the custody of DYS through a legal process. The juvenile did not object to this. He objected to the next question based on a discussion previously at sidebar, and the court overruled that objection. So the testimony of Mr. Olson was not objected to by the juvenile. I just wanted to correct that error.
So do you take the position that the Commonwealth didn't have to prove here that the juveniles were in the lawful custody of DYS? And if so, what's the basis for that?
As an element of the statute, it does not say that the Commonwealth has to prove lawful custody, just custody.
But it doesn't say that in the DOC statute either, does it? Yet it's been interpreted that way?
The DOC, you mean the adult statute?
Yes.
The adult statute said that it says lawful custody.
Oh, it does.
In the adult statute, yes. Under a lawful court order. I have that in my brief. On page 12, or a prisoner committed to any jail or correctional institution under a lawful order of the court. Nevertheless, the Commonwealth presented sufficient evidence that the juveniles were in the lawful custody of DYS, although the statute does not use the term, and the juveniles are not considered prisoners committed to any jail or correctional institution under a lawful court order. Juveniles are treated as the parents.
So I'm not understanding, maybe based on this description of a revocation unit, but was there a minimus that could have been produced?
There is a minimus, and there is orders of delinquency. But this whole, I don't want to say problem, this was caused by the defense or by the juveniles. They did not want this information in. When Mr. Bernard was asked to define what a revocation unit was and what a detention unit was, there was an objection. And the judge said that she would keep it out and instruct the court.
Well, yes, but the juveniles are permitted to require the Commonwealth to prove its case, and they're permitted to object and require the Commonwealth to do it the right way.
Well, I'm saying it was error for the judge not to let this in, because it was, at least some of it, it was the defendant, I'm sorry, the juvenile thought that it would be too prejudicial and that it was irrelevant. But if this information had come in, it would have shown that the juveniles were in a detention center and in a revocation center, that they had committed other crimes, that they had broken their probation. And this is something that the juveniles did not want to come out. And so the judge did her best to trim the evidence, but to the detriment of the Commonwealth.
Well,
Sure,
couldn't
I
the,
think the juvenile's point, though, is even if this was a DYS facility, the specifics as to these youth was what the Commonwealth needed to prove. So you needed to produce some sort of adjudication of delinquency and a detention of some sort, a minimus, really.
I mean, it could have been redacted to eliminate everything but the phrase is remanded to the custody of the department. And as long as it's got a court seal at the top, wouldn't that be kind of sufficient to show lawful custody?
I don't think that it had to be shown, for one. I don't think that it had to be shown.
Okay. Assuming it did.
Assuming it did. Yes, it could have. It would have been objections. There could have been redactions. I don't know how much it would have been redacted, because there would have been a lot to redact. And that might have even raised further flags for the juveniles.
All right,
So-
but just to be super clear, you agree the Commonwealth never entered into evidence a minimus or a prior adjudication of delinquency, right?
Yes, I do. Yes, I do. And if it had been, I'm very sure that there would have been an objection, because the judge was very specific in trying to avoid any type of, as she said, prejudice to the juveniles. But it really was the detriment of the court, of the Commonwealth, and for the juveniles now to come and say, oh, you did not have this information. Well, they didn't want the information in. I mean, they could have cross-examined Mr. Olson on for further information when he testified that the juveniles were in lawful custody. Their hands weren't tied to that. They could have.
But can you envision any testimony from him that would have established lawful custody without resting on hearsay of some sort?
Well, that he knew that there was a minimus, that he knew that they had been adjudicated as delinquent. He was the director and the vice president of these programs. And it can reasonably be inferred that he knew these things, but we're not privy to everything that the judge said to be redacted. And
Right, but saying I know there's a minimus, doesn't that to jump from there to lawful custody assumes that the jury that a minimus is something that the jury understands and knows what it means, and knows that the content of that minimus is an order for custody. But that can't be, that's an assumption. That can't be proven without the minimus itself, can it?
I'm not sure, Your Honor. I'm not sure. I just know that nothing that showed any type of adjudication as delinquent or admittance that they just brought them into the court was allowed. And that usually the juveniles are just brought into court.
Right, so, but the juveniles are arguing that showing that a facility accepts children as a generic matter and that they have an agreement with DYS is not sufficient to show that these two particular juveniles were lawfully detained. And that's what I'm not hearing a satisfactory answer from the Commonwealth.
Well, Mr. Olson stated that they were lawfully detained. I mean, that was our evidence. There was evidence that from Mr. Bernard that this
Right,
is.
but then the question is, what's the basis of knowledge that these particular juveniles were lawfully detained? It would have to be from reading a document, and then we get into a hearsay or best evidence problem.
Then if he read a document, and if you're saying that was the basis of it, I'm just saying this, I'm not saying.
Well, I
that
don't know that we know what the basis was of his statement.
we don't know.
Other than we don't know. And there was a foundation objection, and then a foundation was not laid.
Well, the foundation wasn't laid because if he laid the foundation, he would have had to go into the revocation information and what was going on with the juveniles, that they had broken their probation, that they were in this unit because they had violated probation, and that they may have committed other crimes. And that's why they were there awaiting trial. I mean, it's the Commonwealth's hands were kind of tied in this situation. I mean, he did say that he knew it. If the defense wanted more information, they could have asked them, well, what more information do you have? Is there something else? But we were basically tied because of the defense of the juveniles.
I don't understand why you say you were tied, because you could have offered into evidence the minimus.
And I think that may have been prejudicial. I think the judge would have considered that prejudicial.
But can a judge keep out evidence that's essential to prove the Commonwealth's case merely because it's prejudicial? I mean,
they can.
Looking at the Rule 403, I guess it has to be substantially more prejudicial than probative. If it's the only way to prove that the juvenile was in lawful custody, then it's got to come in. Now, maybe details of, whether it was because of a probation revocation or whether it's for some kind of preliminary hearing or whatever it is, and the nature of the conduct, all that could be redacted out to reduce the prejudice. But surely if a judge said, no, you can't bring in the minimus to prove lawful custody, you'd be up on a 211-3, I guess.
Well, I did put in my brief that the information that the judge kept out was prejudicial to the Commonwealth and that it should have come in. And just because something is prejudicial doesn't mean that it wouldn't be relevant. And
but is the mechanism for that then the interlocutory appeal, or can you raise that now?
Can I raise that now?
Well, you have an appeal, I guess.
Do you have an appeal? Yeah, I mean, is the mechanism for you to appeal at that moment when something can be done about the trial judge's ruling?
I'm really not sure, Your Honor. I'm really not sure.
But you didn't actually offer the minimus, even in redacted form, so we don't know what the judge would have done with it.
We don't know 100% what the judge would have done with it. No, we can just infer what the judge would have done with it. Are there any other questions, Your Honors?
Yeah, can you explain why it would make sense to permit a juvenile to be adjudicated delinquent for escape without the Commonwealth having to prove that the juvenile was in lawful custody of DYS. What's the logic of that?
Well, if the juvenile is in the custody of DYS, I think there you can infer that he is there lawfully. Why is it?
But I'm trying to follow up on your argument that the Commonwealth doesn't need to prove lawful custody. And I'm saying, what would be the logic or fairness of permitting the juvenile to receive a sentence for escape without the Commonwealth having to prove that the juvenile was there lawfully in the first place?
I can only say that the statute does not require it. It's not an element of the statute. I mean, that's the only thing I can say.
Can you give us a reason to treat juveniles differently from adults on that particular point?
Well, juveniles are different from adults.
But
It's
can a reason to treat them more harshly than adults, in essence. In other words, a DYS official or someone running a facility could go out on the street, collar a juvenile, bring that juvenile inside the facility, and if the juvenile runs, the juvenile can be adjudicated delinquent for escape.
so you're saying that would be an unlawful in
Yeah,
custody, unlawful
Yeah.
custody.
yeah, kind of like kidnapping, maybe.
I don't know how to answer that question, Your Honor. I'd really have to think about that. I'm just looking at the statute, looking what was required. Of course, you're not finding case law on this. There's no jury instructions for a juvenile. The statute just says custody. The only thing I have is the test, which I think is pretty good, is the testimony that they were in legal custody. That's what been said.
I hope just one more question. You said, comparing the juvenile statute to the adult statute requires lawful custody or under lawful order of a court. I'm looking at Chapter 127, Section 16 in your addendum, and there are a couple of different statuses of prisoners that can give rise to an escape charge. And the very first one is, it says a prisoner of any penal institution, including a prisoner who is held in custody for a court appearance. So that doesn't require, it doesn't say pursuant to a lawful court order. It just says held in custody for a court appearance. That doesn't expressly say there needs to be a court order or any other statutory authority for holding the person. But yet Section 16 has been interpreted as requiring lawful custody.
I don't have that in front of me, but didn't you say something about penal consequences?
Yeah, prisoner of any penal institution. I'm not saying it applies directly to juveniles, but I'm just saying that the statute does not require in every instance expressly that there be a lawful order of the court in order to prosecute someone for escape. And yet the statute's been interpreted that way.
The adult statute.
Yes.
Same. I'd have to take a look at it and think about it, Your Honor. This has been interesting. I think-
Any other?
No, I'm just saying in my 17 years, this is my first juvenile case. So this has been interesting. It was a learning curve.
Any other questions from the panel? All right, I think we'll have to leave it there. It is an interesting case. And thank you for. Welcome back to the July 15th, 2021 sitting of the Appeals Court. This is our second case this morning, case number 2020-P-0666, Commonwealth versus De Los Santos. We will be hearing from Attorney O'Reilly first.
Morning, Your Honor. Santa Riley for the defendant, Edward De Los Santos. Mr. De Los Santos was the victim of a shooting, and while being treated at Boston Medical Center, a plastic bag fell from his body to the floor, which held 13 smaller plastic bags found to hold crack cocaine. He was convicted of possession of cocaine with intent to distribute and was acquitted of several firearms charges. The defendant took the stand and testified that he had bought the cocaine for his own personal use. While he possessed 2.66 grams of cocaine in 13 plastic bags, There was no evidence of intent to distribute. The weight alone does not raise an inference of intent. In addition, no drug transactions or exchanges were witnessed. The defendant had no cash on him. He didn't have a cell phone, nor did he have any ledgers nor any other indicia of dealing. No
But there
meaning.
was expert testimony.
I'm sorry.
But
Excuse
there
me?
was expert testimony with respect to intent to distribute.
Yes, there was. So the Commonwealth offered the testimony of Sergeant Detective William J. Feeney as an expert to establish that the defendant had the intent to distribute. So expert testimony is allowed to prove a charge of drug possession with intent to distribute because this is not a matter of within the common experience of the jurors. Under McDonald and Grissett, such testimony can be admitted only if it's limited to an opinion that the hypothetical facts were consistent with possession of drugs with intent to distribute. And also, the expert is not permitted to comment directly on the defendant's intent under Acosta. Here, the major focus of Feeney's testimony was profiling the behavior of drug users versus the behavior of drug dealers.
Can you cite any case that treats this sort of evidence about typical packaging practices, sales practices, purchase quantities as inadmissible profiling evidence? I understand that profiling evidence such as, well, users are typically gaunt and thin and look desperate, so this person must have been a dealer, is impermissible. And likewise in the child abuse field, saying, well, this family was under stress economically and because of domestic disputes, and therefore it's more likely that there was child abuse going on. That's the kind of profiling evidence that's been excluded. But what case excludes this sort of evidence as profiling evidence?
Well, in the SJC and Commonwealth versus Horn cited the Commonwealth versus Day case. That was a child abuse case. And the SJC held that the use of criminal profiles as substantive evidence of guilt was inherently prejudicial to the defendant. Here, there was profiling on Feeney's part, and he also testified that, in my opinion, it would be possession.
Right, but I'm asking, I'm staying away from the hypothetical, the answer to the hypo. I'm just focusing on your profiling argument. What case holds the sort of testimony that he gave to be impermissible profiling evidence?
Well, I would cite Commonwealth versus Horn because the SJC, it's 2017 case, the SJC didn't just rely on the, he doesn't look like a drug dealer or drug user language. They did include some additional evidence of his profile, of his other testimony.
So to the extent he testified that dealers typically sell in the following increments, that you wouldn't call that profiling, right?
Profiling consists of several things that he stated.
Well, but if he says, well, one purchase option is an 8-ball and one purchase option is a finger, those would not be profiling, right?
If he's offering the options, no, but he stated that the average person buying would probably buy 1 or 2 bags. In addition, if he testified, if they're going to buy in different increments, it would be worth it for them to buy a bigger package and break it up and use it. But they're not going to go and buy 3 separate increments or 4 separate increments. They're going to get it all in one equal size package. He also testified that he had arrested hundreds of drug buyers and dealers, but they had never arrested a drug buyer who had a firearm. So here, the defendant was acquitted of several firearms charges. And so, I argue that the drug dealer profile, Feeney's testimony, there was very thin evidence of intent to distribute. There were 2.6.
Was there any testimony as to the dollar value of the narcotics in your client's possession?
I off the top of my head, I'm not certain that there was no cash found on the defendant.
Himself around $200?
I'm sorry?
Wasn't there testimony from the defendant himself?
Oh, there was testimony from the defendant himself. But there was no cash found on the defendant. The
Right,
amount-
but in one of our cases, or one of the SJC cases, they said if the defendant was, in that particular case, he had thousands of dollars of, the cash value of the drugs he had was thousands of dollars, and he had like $167 in actual cash, and he was unemployed, and the SJC said those things together was sufficient for him to be convicted of intent to distribute. So that's why I'm asking you if we know the cash value of the drugs he had in his possession.
I'm sorry, Your Honor, I don't know what this, I'll have to, sorry, get back to you on that.
If it's in the record, we'll find it.
However, 2.66 grams alone is not sufficient to establish intent to distribute. It was based.
It wasn't so much the amount, but the packaging, which the Commonwealth relied on. Isn't that the case?
Well, the packaging alone, 13, Feeney testified he has seen drug dealers with 13 bags of narcotics. And, again, he is establishing what drug dealers do and what drug buyers do. And that to establish that the defendant was a drug dealer. The evidence was very thin, 2.66
But doesn't your argument regarding profiling make every such testimony regarding a typical drug transaction, doesn't it really make all of that profiling?
We didn't see any drug transaction here. There was no evidence of any drug transaction. There was no meaningless ride. There was no indicia of any dealing. The defendant had no money on him. He didn't have any ledgers or any indicia of dealing. So that's very thin evidence. The evidence alone, 2.66 grams of cocaine in 13 plastic bags.
So the Commonwealth cites a case, Commonwealth versus Gonzalez, for the proposition that there was a bundle of 10 packets with an elastic band, and that was indicative of evidence of intent to distribute. How do you distinguish that case?
I believe in Gonzalez, there is a lot more evidence. Here, there is no evidence. There is no witnessing of any drug transactions. And it's just extremely thin evidence. And
well, if he had let's say he had $2,000 worth of crack cocaine on him, and that was it, would that be sufficient evidence?
He had 2.66 grams of cocaine on him. And so
No, I understand it's not this case, but we have to think about your case and every other case that might come before us. So we do have to think about where the lines would be drawn. So
yeah.
if he had $2,000 worth of crack cocaine on him, and that how many doses of that would that be sufficient to sustain the conviction? Or why wouldn't it be?
Well, I would argue it would depend on the other indicia of dealing. The courts generally don't find one factor in these cases. They generally they look at several factors, whether there was any drug transactions witnessed, meaningless rides, whether the defendant has cash on him, proximity, if he's in a car, of the drugs to the defendant. There's several factors that they look at. Here we have 2.66 grams in 13 plastic bags, and that is it.
Are you aware of any other case where it's the packaging and the amount?
Not just
makes the case?
It would be much greater amounts and than 2.66 grams, because 2.66 grams of cocaine does not, and it's the weight itself doesn't establish the issue. It doesn't raise an issue of intent.
May I ask?
Go ahead, Justice Sachs.
May I ask a question about your closing argument issue? You challenge a couple of things said in the Commonwealth's closing argument, and I want to start with the second statement that you challenged, which was the prosecutor's statement, and he, meaning Feeney, sorry. And he's never seen a user buy more than 5 bags at once. And when he did that time, the users were pooling their money. that seems to me like a straight and accurate recitation of of Feeney's testimony. Do you have a problem with that statement?
Yes, I do. I have a problem that Feeney's testimony, which was over the top regarding profiling, was emphasized in the closing.
Okay, but you don't think that that closing argument in and of itself crossed any lines. Your issue is that it was based on testimony that you say should not have been admitted. It wasn't a mischaracterization of the testimony, was it?
Let's see. He's never seen a user buy more than 5 bags at once. And when he did that time, the users were pooling their money. Yes, I would consider that an inadmissible expert testimony because it makes it more likely than not that the defendant,
Okay, but he's accurately the prosecutor is accurately recounting what Feeney said, separate from whether Feeney should have been permitted to say that. Once it was in, did the prosecutor act improperly in reminding the jury of what Feeney had said in that statement?
I would argue that he did act improperly because there was no evidence of anybody else other than the defendant, or that there was any pooled. Yeah, I would consider that his emphasis on Feeney's testimony in the closing helped create a substantial risk of a miscarriage of justice.
Because it amplified the error that you say was present in
Throughout.
Admitting Feeney's testimony. Do you say, if we assume for purposes of argument, and I'm not saying that any of us has reached this conclusion, that Feeney's testimony were improperly admitted, or were properly admitted, I'm sorry, would you still have a problem with the closing argument? Or is it just that the closing argument amplifies the effect of what you say was the error in admitting Feeney's testimony?
I would say Feeney's testimony was improperly, should have been excluded, and that the closing argument with the emphasis on Feeney's testimony also was inherently prejudicial to the defense.
So are the two arguments inextricably linked? In other words, hypothetically, if we determine that Feeney's testimony was proper, does that automatically make your challenge to the closing argument go away, or would you still have some challenge to the phrasing of the closing?
I would still have a challenge to the phrasing of the closing argument.
And what would that be?
Because Feeney is, his profiling evidence is getting repeated.
Right, but if we decided that his profiling evidence was proper, hypothetically, was it repeated in any way that was improper or inaccurate or unduly prejudicial or violated due process or any of the other problems that, burden shifting, any other problem that we typically see in closing arguments?
Well, it would inflame the jury. And I would say that Feeney's testimony, I can't see that it was proper. And so this, along with the emphasis in the closing, would, inflame the jury and materially influence the verdict, because the jury is relying on expert testimony to understand the intent to distribute. So if we have an expert opining about the intent to distribute and not using the consistent with language, he testified, I believe the last question, his answer was, in my opinion, it would be possession with intent to distribute it. So that's a violation of Acosta. So I don't understand. I really.
Commonwealth argues if there had been an objection, then he would have simply rephrased his answer in the proper form. So what do you say to that?
I believe Acosta has dealt with, this issue that the consistent with language has to be used, because experts are not supposed to give their opinion about the guilt or innocence of the defendant. And so that was a violation of Acosta. That was also a violation of McDonald and Grissett, especially
even here where the question itself said hypothetically, and even where his answer said would be, not that this defendant is guilty.
I believe the case law is quite specific. Testimony can be admitted only if it's limited to an opinion that the hypothetical facts were consistent with possession of drugs with intent to distribute. And, it's a matter not considered within the common experience of jurors. So if Feeney says, in my opinion, it would be possession with intent to distribute it, and that's the last thing the jury hears from him, then they are more likely to convict him and of intent to distribute without any other evidence of intent to distribute other than 13 bags and 2.66 grams. And in that case, a substantial risk of a miscarriage of justice was created.
All right, thank you very much. We have that argument, and now we will hear from the Commonwealth and Attorney Jordan.
Good morning. May it please the court. Darcy Jordan on behalf of the Commonwealth. Commonwealth is asking that this convictions be affirmed, that there was no error in the admission of Sergeant Feeney's testimony, and the evidence was sufficient to support the conviction. Just turning to the question in the record about the transcript, that whether or not there was testimony regarding the dollar amount, Sergeant Detective Feeney on page 91 of his testimony doesn't specifically do the math, if you will, about this amount, but says a 0.05 bag would be $5, 0.1 would be 10, 0.2, and so on and so forth. And even I'm really bad at math, and the 2.66 grams here, I would suggest that it was inferential, not only for us, but for the juror. That would be about $260 worth of crack in those 13 bags.
But that weight includes the packaging of 9 or 10 bags, right?
You know what? I'd have to look closely at the chemist's testimony, but typically speaking, I don't know exactly how the chemist did it. But sure, there's discrepancy, a few ounces.
There were some bags where the contents were taken out and weighed separately, but the majority of bags were just weighed in a group, as I understood the testimony.
That's my understanding. That's my understanding as well. And based on, I think that's, in my experience as a prosecutor, that's typically how chemists not only weigh and evaluate the evidence, but also how they testify to it as well. And clearly that kind of testing has been sufficient in numerous drug cases in the Commonwealth.
So for context, a pound is 454 grams. So 2.6 is fairly small, right?
Fraction of an ounce.
Yes. I mean, I think if we look at all the drug cases in the Commonwealth, we could go from smaller to larger, but like all drug cases, when we are evaluating possession with intent, where there is no hand-to-hand sale or this kind of distribution that's been observed by the officers, we're really dealing with inferences based.
Right, but do you have a case that says that just having these separately packaged different amounts, 13, like what's the smallest you have? Because the cases you cite all seem different.
Yes, because Your Honor, there's never going to be a case that's exactly as you know. I think I cited Smith.
I know, but like Commonwealth versus Gonzalez, first of all, that involved heroin, not crack, but each package was marked with a brand of a scorpion, indicating one dealer's brand. The defendant was employed, had $167 in loose currency, and he had $180 to $200 worth of heroin. And that case was a close case.
Absolutely. I think in Smith, which I think is very analogous, and I point out in my brief, I think I'd have to go back and look, but I think the amount was similar in that case. But and I think I might have also cited a case where it might have been 3 grams, which I think is pretty close to this amount of grams here. But Your Honor, I'm not disagreeing with you that this is a small amount. But just like all these cases, it's the totality of the circumstance and the aggregate of the evidence, and also vis-a-vis the expert testimony that is giving meaningfulness to that weight. So I'm not disagreeing with you that that is a smaller weight compared to some of the other cases that just really looked at the weight as though, if you will, the major indicia of distribution. That's simply not what we have here. We have like a street drug dealer dealing with street level increments. So I'm not disagreeing with you that alone, the amount wouldn't alone get us there, but here we also have the way it's packaged, the fact that it's in different increments, the fact that it's hidden in his groin area, the fact that it's one bag containing the 13, the fact that he has other paraphernalia to consume it, all of those things in the aggregate give meaningfulness to, if you will, the smaller weight. So I know I do cite cases that are more closer in the weight, but you're right. I don't think I have one that says,
Yeah, what do we do with the fact that he was shot? I mean, he fled. So we don't have any idea what he dropped or was stolen from him or what have you before he was shot. There's a lot of mystery there.
There is, I do not disagree with that point. And obviously the jury also agrees with that because they found him not guilty of the firearm. That was part of, if you will, the Commonwealth's narrative before the drugs were found.
Evidence of whether he was shot with the firearm that was found on the tire near where he was, or was he shot by a different weapon? And I ask that because we have testimony from Sergeant Feeney saying that users don't bring weapons. And so it seems quite significant that we have a gun that was found near him, but do we know what he was shot with?
The Commonwealth, no, I don't think any ballistics.
That's what's concerning me then about all this testimony from Sergeant Feeney, because he's just said this guy has to be a seller because buyers don't bring guns to a transaction. And yet it seems like that we have a different scenario here because somebody brought a gun to him. I mean, it could have been a rival dealer. I get that, but it is a big question mark here and points out the defense concern about profiling.
Well, I think the easiest way is almost work backwards from your point, in that the jury found him not guilty of the firearm. So even if Sergeant Detective Feeney's testimony was improperly admitted, the jury didn't believe it because they found him, or didn't find the gun meaningful here because they found him not guilty. So even if we look at the jury's verdict, they found him not guilty of the gun and guilty of the possession with intent. So either we're arguing that those verdicts are inconsistent, or we're arguing that the jury didn't believe necessarily Sergeant Detective Feeney's testimony that was meaningful in this sale.
Right,
so,
but however they got there, if the gun that was found was not the gun that was that was used to shoot him, then there was another gun, right? And he's saying that a buyer would not have brought that gun.
Right. And well, you also have to look at it the defendant testified and said that the gun that was found and, with the blood on it, he had struggled away from this unarmed assailant. So I think based on that testimony, and again, I know we're trying to kind of go behind the jury's verdict, if you will, but even if the jury accepted that part of the testimony, then I would suggest that the gun's calculus in whether or not the drugs were consistent with sale was not meaningful for the jury here. Because if it were, then I would suggest that the verdict would have been guilty on the gun, guilty on the drugs. So the fact that Sergeant Detective Feeney is saying, hey, dryer buyers may or probably don't have guns, I suggest wasn't a part of the calculus based on the other evidence and with the jury's verdict.
So was Sergeant Feeney's testimony that he'd never arrested a drug buyer who had a firearm, was that profile evidence?
I guess if any of his testimony does come close to profiling, I guess that's the closest. But I think if we understand and the courts have gone over and over what profiling evidence is and what modus operandi evidence is in drug cases specifically, I would suggest to you that it wouldn't be in this case, or it would not necessarily be so, because if we're talking about how drug dealers deal drugs, then they sometimes have guns or weapons to arm themselves, and that would be part of the modus operandi, and not necessarily that all drug dealers always use guns and all drug dealers don't. Because I think what you also have to look at is Sergeant Detective Feeney was also crossed on this point, and where he was elicited that, it doesn't always happen this way. It was kind of equivocal on cross. So I think the meaningfulness of that testimony just doesn't bear out that the jury would have made a difference in this verdict.
Counsel, can I ask you a question about, sorry, go ahead.
Go ahead.
I wanted to ask you a question about the prosecutor, I believe in closing, mentioned the significance of the lack of blood on the bag. And I had a hard time in the record trying to figure out where it's established that there was no blood on the bag that the drugs were found in.
You know what? I'd have to look at the transcript for that, but I know that all the testimony that was about the bag was from the doctor, the medical doctor. So I think, even when I was looking through the transcript, I was almost looking for more details about that from the medical, and you can kind of tell that the testimony is really from that medical perspective. Like, hey, we saw a bag and we didn't really think much of it from the forensic securing evidence kind of way. So the evidence is what it is. There's no blood on it. And I don't know, I have no idea if that's because it was recovered in the medical setting or not. I agree with you that that's not in the record though.
But the bags were in front of the jury?
Yes, yes. If I could
he was shot in the scrotum, right? And that bag fell from his groin area?
Yeah, it was found. Yeah, it did. Yes, it fell from his perineum. So it was, secured close to the body, under, on his skin with the underwear over it. And if I could just turn to, I know my sister makes her main argument is that about Sergeant Detective Feeney's testimony and the ultimate question that was asked. And I just want to highlight that the ultimate question did not ask what was the defendant's intent here. That ultimate question was really about what are these drugs consistent with? What kind of inferences can be made from the drugs? At no point did Sergeant Detective Feeney answer or was even asked, what was the defendant here doing? Meaning the ultimate question was still in the purview of the jury, even though that talismanic language wasn't used. And I think Tanner, which is a 98 case, and Madera, which is a 2010 case, which I cite both in my briefs, talk about, when this language consistent with isn't used, what does the court really need to evaluate? And it's whether or not the testimony from the expert was explanatory, and whether or not that ultimate question was just conclusory. And Sergeant Detective's testimony here was really that generic testimony given by experts in drug cases. The packaging was, knots, the amount of drugs in different increments allowed
where
for
the
quick
facts
sale.
of the hypo exactly match the facts of the case. How hypothetical is it?
Well, I think, and this court and the SJC has talked about, of course, the hypothetical is going to mirror these cases, and that's absolutely proper. To not do so would render that expert meaningless. There would be no point in not asking directly the meaningfulness of the evidence here. And the hypothetical here was whether or not what was the 13 bags? What would you? And it was, I guess, my point, not very articulate, was the hypothetical was geared right toward the 13 bags. It wasn't geared toward the defendant's behaviors, if you will, but what inferences could the jury, and I would suggest that it wouldn't be in their common knowledge about what 13 bags and small increments like that found in the scrotum would actually mean. And just to touch upon the sufficiency of the evidence, I think I briefed it pretty well. And I think I know I cite to you the numerous factors at each point, the smaller increments, what their meaningfulness, the total of the packaging, the fact they're in the scrotum, the lack of paraphernalia. And, my sister points to other kind of inferences or that the jury could have made, but in the light most favorable to the Commonwealth, the manner in which the defendant was holding these and the manner of the packaging would is sufficient for them to find the defendant guilty. And I ask the court to affirm.
Any other questions? Thank you very much. The case.
All right, we are live and recording.
Excellent. This is a continuation of the July 15, 2021 sitting of the Appeals Court. We're calling case number 2020-P-1376, Department of Children and Families versus Mother. This case is impounded, so we'd ask you to refer to mother or parents or child and not to reveal anyone's names. We'll hear first from counsel for mother, Mr. Hoffman.
May it please the court. Good morning. My name is Andrew Hoffman. I represent the appellant mother who is the respondent in this care and protection case. I'm asking on her behalf this morning that this court vacate that portion of the October 2019 decision that terminated her parental rights. She was first found unfit at a trial that occurred in the fall, September of 2018. She concedes that she was still unfit at the time of the, what I'll call the second trial, the trial that is the substance of this appeal, which resulted in October 2019, which resulted in the termination of parental rights decree, which she now appeals. So I'm arguing that the juvenile court erred not in finding her unfit, but in terminating her parental rights. The first and primary basis, if you will, for my argument revolves around the inference that the juvenile court drew of a bond between the child and the child's pre-adoptive home. I'm arguing it was unreasonable.
Counsel, I am trying to understand your argument because I thought after the judge found her unfit after the first trial, the judge was giving mother a certain amount of time to try to become fit and that she did not. Are you saying that there had to be some additional change in circumstance before the judge could terminate parental rights?
I am, Your Honor. And honestly, that was somewhat confusing procedure. If you read the findings of fact and conclusions in law without having known any of the background or read the transcript, you might think that it was one uninterrupted proceeding in court, one trial from start to finish. It was not. There was a trial that was held in 2018. The judge issued a written decision. No party appealed that. The Department of Children and Families filed a motion for review and redetermination about 3 months later, 4 months later, I guess 3 months later, in December of 2018 to initiate further proceedings to terminate parental rights. The judge issued what he called an adoption of Carlos decision. Quite honestly, that terminology doesn't appear anywhere in statute or in case law. The best I can tell, that's a local idiom that the judge used, but there's no mechanism under the law for this kind of continuing open evidentiary record. The way that it was properly considered here, and what I'm arguing in my brief, is that it was a discrete proceeding in 2018. There was a decision. There was no termination of parental rights, so all parties retained their right to review and redetermination. DCF then exercised its right to review and redetermination. The case then was scheduled for and proceeded to a second trial, at which the evidence from the first trial would be admissible and certainly relevant. But yes, Your Honor, to answer your question, my argument is very clearly that because the court found in 2018 that there was not a basis for terminating parental rights, and in fact did not terminate parental rights, that therefore there would in fact have to be a change in circumstances in 2019 such that where it was not in the child's best interest a year ago in 2018 to terminate parental rights, there would in fact have to be a change in circumstances a year later in 2019 in order to terminate parental rights.
It seems that premise is a bit off, that what happened in the first proceeding was that the judge found there was not a basis to terminate. It seems that there may have been a basis to terminate, but there was a decision not to do so at that time.
The judge wrote that there was a sufficient basis to terminate parental rights, but he decided nevertheless not to terminate parental rights. I think the only reasonable reading of that is that DCF did not meet its burden of proof at that time. The judge has obviously a duty to make decisions that are in the best interest of the child. And so I think the only reasonable reading from the fact that the judge did not terminate parental rights is that he found that it was not in the child's best interest to do so. Had there been a need to terminate parental rights to serve the child's best interest, he was obligated to do so and would have done so. So I think that's the only reasonable reading, is that DCF, that's the only way it can be read, is DCF did not meet its burden of proof in 2018, and that therefore the status quo was unfitness, continued permanent custody of DCF, and unless and until some party moved for review and redetermination, that would remain the status quo. And then the case proceeded to trial in 2019, only because DCF did pursue its right to review and redetermination under statute, under section 26, 119.26. You look perplexed, Your Honor. I agree. It's an unusual, I think, way to proceed. And like I said, part of the problem is that when you read the conclusions of law and findings of fact, it does make it sound like it was one uninterrupted proceeding that flowed from the very beginning of the presentation of evidence until the end. But
is the department, do you challenge any of the findings of fact?
No, I'm not. What I'm challenging, so the primary one that is an issue that really my first and primary argument about the inferences revolves around is finding of fact 212. And that is the finding at which the judge inferred, without any expert opinion, just drew an inference of a strong connection between the child and the pre-adoptive home. He used terms like well integrated and close attachment. He cited the foster mother's ability to soothe the child and the fact that the child sought out comfort from the foster mother. And what I'm arguing is that inference was not reasonable and therefore was erroneous. I didn't characterize that as challenging the finding of fact in my brief. I'm not sure if it's exactly the same thing, but what I'm arguing is that the inference in and of itself was erroneous, and the court therefore abused its judicial discretion by drawing that inference.
So the department or the child, I don't recall which, argues in response that that even if you're right on that point, it does not change the outcome because that was just a small part of what the judge did. What do you say to that?
I say it's not just a small part of what the judge did. I say it is really the entirety of the substance of what we were just talking about earlier. Your first question, Your Honor, which is that there was a change in circumstance. And then let me back up. There had to be a change in circumstance. In order for the court to terminate parental rights in 2019 in the second trial, there had to have been a change in circumstance. Absence of change in circumstance, there would be no basis for terminating parental rights in 2019. I'll say the main change in circumstance from 2018 to 2019 was that the child was placed in a pre-adoptive home. The mother's circumstances hadn't changed. In fact, were strikingly similar to a year prior. I'll go back even farther than that, for several years prior. She had continued her instability, the criminal charges that resulted in incarceration, her inability to achieve meaningful progress in services. All of those circumstances in mother's life remained the same. The other change that I will note is that the father, his rights had not been terminated at the 2018 trial. By the time of the 2019 trial, his rights were terminated. I'll mention adoption of Willow, which is cited in my brief. That is a case in which the Supreme Judicial Court gave its blessing to the termination of parental rights of one parent, but not the other. And so if the judge in this case had determined that even though the father's rights were not going to be terminated in 2018, if it was necessary to serve the child's best interest to terminate mother's rights, he could have done so. He did not do so. So therefore, again, I'll go back to my point, which is DCF failed to meet its burden of proof in 2018. So there had to be a change in circumstance. The only relevant change in circumstance at that point was the fact that the child was in the pre-adoptive home. The fact that the child was in the pre-adoptive home in and of itself is not a basis for finding that the child's best interest would be served by termination. There has to still be some analysis of the child's pre-adoptive home and how and why that pre-adoptive home serves the child's best interest. And that comes from this.
Counsel, why was it not a change of circumstance that the mother had a significant additional time to improve her situation and did not? Why is that not a change in circumstance?
because it's a continuation of circumstances that had existed all along. The court found in 2018 that there was an insufficient basis to terminate parental rights with knowledge of several years of these exact kinds of circumstances in mother's life. The things that were occurring in 2018 at the time of trial and then occurred from 2018 to 2019 were not new. They existed in mother's life throughout the prior several years, detailed in the findings of fact. And so that is not a change, that was continuation, and it was not sufficient in 2018.
Yeah, but why is the indictment there that the judiciary was just, or DCF was just too slow to act, not that there was not a change in circumstance?
I'm not sure I'd argue that they were too slow to act. There is certainly case law precedent. Adoption of Nancy is one that comes to mind. There's others that stand for the proposition, this notion that, quote unquote, enough is enough. In other words, over a period of time, a parent given ample opportunity to improve their circumstances that fails to do so, that it's fair for their rights to be terminated. But again, every case is different. And what I'm arguing here is that all of those factors were in place in 2018, and they were not sufficient for a basis for termination in 2018. It's not clear why they would, I'm not going to say suddenly, but a mere year later, be sufficient without any other change in circumstance. That's why I continue to cite to the fact that the child was placed in the pre-adoptive home. That really was the only palpable change in circumstance.
Well, perhaps the change was that from at the first proceeding, there was a hope that the mother could improve. And a year later, that hope was gone.
I think there was hope throughout. I mean, the mother had been involved with DCF for several years. This was not the first care and protection case filed on her. Her older child was the subject of care and protection case. She'd been involved with DCF for several years prior. So I think there was I won't say an expectation, but certainly an anticipation or hope that she would improve, and she had not. And so again, that circumstance that existed in 2018 and then again in 2019 had existed all along. And again, Adoption Nancy, other cases do give the court the authority to say at some point enough, but there needs to be some triggering factor. There's no magic to saying it's 6 years instead of 5 or 5 years.
I might have missed something, but is there any language in Adoption of Carlos or any other case that says in a situation like this, there actually has to be a change in circumstance other than merely the passage of more time, after which it can be more, the judge can be more certain that the parent's unfitness is not merely temporary? Is there
the passage of, I'm sorry,
let me try to break that up. Is there any language in Adoption of Carlos that you rely on?
No, I do not. There is certainly language in case law, Carlos, and elsewhere that says that the continuation of circumstances over a period of time can eventually serve as the basis.
So what case says that in a Carlos situation where the judge has found unfitness but has not terminated because it's not in the best interest, that there must be a change in circumstances before at a future proceeding the judge can terminate?
Right. I would cite to the case law on review and redetermination, Chapter 119, Section 26. Care and protection of Aaron is the seminal case there. That
any of those involve Carlos type determinations where the parent had previously been found unfit?
Not that I'm aware of specifically. The reason I would cite to Aaron is this notion that you have a status quo. You have a decision where it was found that it was not in the child's best interest to terminate. So you stop there and you say that is the status quo. Yeah. And we're not going to do anything further until somebody comes in and proves that there is now some change in circumstance that would indicate a change in the child's best interest. And so why I'm arguing, I realize I don't have much time left, but I'll just make the point quickly. And I addressed this in my brief, but I'd like to address it here, is really, it's not to get too esoteric, and it's not that esoteric or theoretical, but just the notion that an inference is reasonable only if you can exclude equally plausible inferences. And here, there wasn't an evidentiary basis for the court to exclude an equally plausible inference as for the child's problems in the pre-adoptive home. The findings of fact details some pretty extreme behaviors in the pre-adoptive home that correlate with his time in the pre-adoptive home. He had trouble before placement there, no question about it, and those behaviors did continue to some extent. But he had much more severe behaviors after being placed in the pre-adoptive home. It's tempting to infer that that is because of his ongoing contact with his mother, which in this case was not consistent, but which was tied together in the evidentiary presentation that this was somehow as a result of his contact with mother. It's equally plausible. There's a copious amount of literature, a couple of samples of which I cited in my brief, that state that the opposite conclusion is equally plausible. That this child spent the first year and a half of his life with his mother. He was with the pre-adoptive parent for a year at the time of trial. And so it's equally plausible. There's nothing in the evidentiary record that would lead the finder of fact to one inference versus the other. And unless until the court can point to a basis for inferring that the child's problems in the pre-adoptive home were because of the mother and the ongoing contact, as opposed to the fact that the child's pain was caused by continued separation from his mother, that's not a reasonable inference. It's therefore erroneous and would be a basis to vacate the decision. I see that my time has expired. I'm happy to answer any further questions that the panel may have.
Any questions? We will now hear from
Thank you.
the department. Attorney Murphy.
Good morning, Your Honors. May it please the court. Lynn Murphy for the Department of Children and Families. The trial court absolutely and properly terminated mother's parental rights in this case. This parent had been involved with the department 6 years of services, not able to parent her older child, termination there. We reunified, the department reunified mother with the older child. That also did not work. She has, she had an extra year. Now, I think what's happening here is we're getting caught up on the strict definitions of changed circumstances. And the bottom line here is the trial court could have, and in fact said the department had met the burden for termination.
Where is that in the record then?
Yes, that's in the trial court's findings. I will have to look at it again, but if I don't put my hands on it quickly, I can certainly follow up with a letter, but and I think in my brief, I've noted it, but
if it's in your brief, we'll find it.
Yes, there was overwhelming evidence that mother's rights, the mother was unfit and unlikely to become fit. And with the strict reading of Carlos, actually the court is supposed to only be able to continue the matter if there was a reasonable cause to believe or reason to believe that the parent will correct the condition or weakness. There really wasn't. There was nothing to really suggest that she would, but I think the judge wanted to give her every opportunity. In fact, this mother has had every opportunity from the department and from the judge to correct her circumstances. So at that point, the mother was given another year. The judge did this because the department.
Start with the basic though. Do you think that the department had to prove a change of circumstance, or do you think it was, or that I guess that's just a question by itself. And then the second part of that is if the answer to that is yes, then is that satisfied that by proving that the mother's circumstance did not improve?
Yes. Well, I think, again, because of the way that the judge provided mother the extra year when he or she could have terminated, at that point, when the review and redetermination motion is filed, the department does have the burden of showing what has changed. Now, in this case, technically speaking, mother's counsel is right. There was nothing had changed. We're talking about 6 years of significant problems, but also there was a hope that mother would finally use that year, knowing that she would face termination, and maybe this would be provide the incentive she needed to break this history, and that just did not happen. So I think that there was more to get caught up in the technicality of what did change circumstances really mean. We don't need to get into that because This is a mother who was given every opportunity. And if there's any stumbling block here, it was because the judge was kind enough to give her another additional year, which the judge did not have to do. And basically, when you look at this, there were 3 or 4 primary factors for termination here. These are significant unfitness, significant areas of unfitness. She had a lengthy substance abuse history, lengthy criminal history, which involved numerous incarcerations. She had an unstable living environment. She was not able to maintain, follow program rules. She was thrown out of halfway houses. She was involved with domestic violence. And there were a number of secondary factors the court also considered, which was her mental health issues could have created a barrier to her ability to improve improve her parenting skills through services. However, she would not participate in the psychological evaluation, so the department was never able to fine-tune those services. The bond that the child developed with the foster parents, pre-adoptive parents, played a very insignificant role and was definitely a secondary factor. And the bond that the mother shared, it was not relevant as far as it doesn't whatever bond she had was recognized for the visitation piece. The order of visitations, she still had a connection. Court recognized that and entered the order for post-adoption visitations. But that does not impact the unfitness or her, or that termination doesn't serve the child's best interest. Termination, there could be no question that after this amount of time, the child was waiting in foster care for more than half his life. He only resided with mother for about 1 year. And she was never able, despite the efforts of not only the department, but the trial judge also, the mother just is not able to parent this child at this time. So at this point, the judge terminated.
So the mother argues in her brief that the social worker admits that he did not follow DCF policy regarding visitation with the mother while she was incarcerated. And frankly, we see findings like that more than I think anyone would like us to see that. But the judge then says that the social worker admitting this blatant violation of DCF rules enhances his credibility. So, and that is concerning because that's not what courts should be doing. What do you say to that?
Well, I think what the judge, that is a little bit of an awkwardly worded finding. I think what the judge was trying to say was that this social worker was making efforts to have mother visit. But mother was in and out of, would be incarcerated for short periods of time. You have to be registered as a visitor. You have to arrange for these visits. And I think what happened was it was such a short period of time, mother would be out. And then the evidence did show through his testimony and through court reports that the social worker was concerned and wanted the visits to be held in a more appropriate place. Particularly, this is a 3 or 4-year-old child. And I think at that point, the judge noticed or took note of the social worker's testimony and did find that despite these short lapses where visits didn't take place, that the department was making attempts to continue the visitation and had done quite a lot. It was just at that those few months. We're talking about 2 months in the spring and then 2 months. So in 2009, mother had 5 visits set up, 4 to 5 visits set up by the department. And we're only talking about 4 months that she was incarcerated. And one of those months also, the child didn't want to visit. So there was definitely other factors involved. And I think the court was noting that.
May I ask, since your time is almost up, is it fair to say that the judge's rationale for not terminating, despite the finding of unfitness, is set forth in the judge's order of September 25th, 2018?
Yes, I think that is where I read that.
All right.
Because the department was working with father. We were hoping to reunify with father at that time. And the judge, quite to be just blunt, I think the judge said, well, we're not going to let's just give mom another year. The department's working with the father. Let's just wait and see if mom can, follow services and address her unfitness, then we'll take another look at it. If there are no other questions, I will rest on my brief.
Thank you. And now we'll hear from Attorney O'Brien for the child.
Morning, Your Honors. Tamika O'Brien for the child. Your Honors, there's been a lot of talk about change in circumstances here, and the child argues that there is a change in circumstance. The fact is that in the 14-month period between the time of the first trial and the second trial, there were approximately 420 days. And of that 420 days, mother was incarcerated approximately 176, so about 42% of the time. That means that mother was unable to do any of the things on her service plan, set herself up, with stable housing, get the psychological evaluation that the department had repeatedly asked her to get so that they could kind of tailor her services to her needs and the child's needs. Just that change of circumstance right there is huge. It's not just that she had a continuation of her same behavior. It was for 42% out of this 14 months, she wasn't available to parent the child, to care for the child, to work on herself. So that left this child in limbo. The trial judge did find in September 25th, 2018 order in paragraph 6, the judge found that there was clear and convincing evidence to terminate. However, the child's interpretation of this is in support of DCF's interpretation, which is, dad's trial was scheduled for later. Why terminate mother's rights right now since she was doing some services? This child wasn't going to be free for adoption until dad's rights were terminated as well. So I think that even though the court did find admissible and credible evidence, clear and convincing evidence to terminate mother's rights, he did give her an extra year, more than a year, which she did not take advantage of. I wanted to address.
So let's just assume for the sake of argument that mother just stayed exactly the same, that she wasn't incarcerated, but she continued to have all of her exact same problems. Do you think that the judge would be able to terminate after that second trial?
Yes. Again, it's a continuation of the first trial. She's still, the judge had the clear and convincing evidence in the first trial. That same clear and convincing evidence carried over into the second trial. She didn't, none of the protective factors that the court had hoped that she would work towards and ameliorate had been corrected. Mother focuses a lot on this lack of expert evidence. As we know, it's not required, but even if it was dispositive, it was just one factor in a constellation of factors. We're looking at the fact that this child has special heightened needs. Mother was not able to provide for those. She had, as we discussed at length, frequent incarceration, substantial mental health needs, which she was not working with the department to address in terms of getting the psychological evaluation, substance abuse, mental health, the list goes on and on.
May I ask, would the fact that the father became essentially unavailable as a candidate for reunification during the 14 months constitute a change of circumstances that could support the termination of the mother's rights after that time?
The child argues that, I would argue, yes, it does. It gives the DCF the opportunity to say, okay, mom hasn't done what we'd hoped she had done. Dad at this point is not going to be in a position either. So let's move on. Let's get this child into some kind of permanency that he deserves.
In other words, that if dad were still a possibility for reunification, there might not be a need to terminate as to mom. But once dad was no longer available, because nothing really would be accomplished by it.
Right.
But once dad was no longer available, then there was no reason, particularly coupled with mom's lack of improvement, to hold off any longer.
Sure. I mean, like I said, I think that part of the judge's reasoning here, and obviously I can't get into the judge's head, but part of the reason is the child can't be freed for adoption if dad is still, in the picture. And once dad's not in the picture and mom hasn't done what she's supposed to, but, what we'd hoped that she'd worked on, that kind of leaves the child in limbo, and DCF moves forward with the motion for redetermination, review and redetermination. I do want to point one thing out here that, DCF, the social worker admitted that the regulations may not have been followed as far as visitation, but while we would always like them to do better, and they always can, in this situation, the visitation wasn't terminated, it was suspended, and mother frustrated this visitation on her own a lot. When she did show up, it was often she appeared impaired, she brought sketchy men, she brought animals to the visit, she moved from Grace House to Serenity House and then didn't tell her social worker, so they couldn't find her. So it wasn't just on DCF here. Mother does have some responsibility to cooperate and not frustrate those visits with her child. Your Honors, the appeals court is a court of error, correction, and here there's no error. Or if there was, it was harmless at this point, and does not rise to the level required for reversal. If the court has no further questions, although I'd be happy to answer any, I will rest on my brief.
Thank you very much, counsel. The case is submitted.
Thank you. Have a great day.
Thank you.
All right, we are now live and recording.
Thank you. This is the last case we have today on our July 15, 2021 sitting. It's case 2020-P-0850, Soar versus Lim. And we're only hearing argument today from the attorney for Ms. Lim. And so, Mr. Lindauer, we are ready for your argument.
Good morning, Your Honor, and may it please the court. My name is Kenneth Lindauer. I represent Ms. Lim in this matter. This case is about a interpretation of a deed for property acquired by Ms. Lim from Mr. Soar. It was industrial property in Lowell. There are a number of issues that concern the deed, and I think I'll address them one at a time. The first issue deals with the recording system in Massachusetts. This was a quitclaim deed that conveyed property to my client. The language in the deed was very specific. It said that Ms. Lim was to pay the seller, $40,000 at closing and $40,000 in 2 years after the closing. The second payment was not made on time, and that was due to a number of factors. Ms. Lim testified at the hearing that she didn't know how to pay it since Mr. Soar was in a personal bankruptcy at the time. However, she did offer to pay it to him. After that, Mr. Soar refused payment, and this case ensued after that. The trial court judge found that the deed in question was a fee simple determinable, and that the fact that the payment was not made on time required that the title revert back to Mr. Soar. It's my argument, and I think my brief is relatively clear about this, that case law is pretty clear that for fee simple determinable to be found, there has to be specific language in a deed creating the fee simple determinable. And
well, does the case law really indicate that there has to be that language? Isn't that more that typically you would find that language?
Well, the case law, the Massachusetts, the land court in the Winchendon case, which cited a federal court case and the appeals court, said that the property owner who has the right to impose limitations and conditions on an estate has to impose conditions on the estate that would reflect that the property be returned to them, revert back to them. A fee simple determinable is created by a conveyance which contains words effective to create a fee simple, in addition, provision for automatic expiration of the estate on the
So why
occurrence of
isn't that provision the second payment?
Well, it's not an automatic reversion. It's a remedy that the seller would have to collect the money, but it doesn't state that the property would revert back to him. He has the right to sue for damages. This type of if this is determined to be a fee simple determinable, as a title attorney, I think I see potential serious problems with the title examination, because in the future, how would the owner of the property ever be able to sell the property if the prior owner doesn't sign a discharge or a release of some sort of document indicating that the payment has been made? Then the title would never be cleared. And this sort of obviates the need for a mortgage statutes and all the other requirements that we normally comply with when we're dealing with title examinations. The court has stated over and over again that a fee simple determinable is usually created by using words of limitations, such as during, as long as, until, and so forth. And none of that was included in this particular deed.
Well, so counsel, if we had that kind of deed that said, provided she makes a second payment within 2 years and she didn't make the payment, what would the seller do at that point to quiet title?
The seller, at that point, if that's what it said, the seller would file a suit such as this. But that's not what the deed said in this case. And it doesn't say that the property would revert back. And I think that language has to be very specific about that. Otherwise, the concept of the sanctity of the quitclaim deed is gone. There is a presumption in the law against forfeiture of property. The article that I cited in my brief from Professor Singer at Harvard Law School clearly stated that the presumption against forfeitures of title suggests that any retained future interest must be created explicitly and unambiguously. And that's not what happened here. This is just a deed where there is a schedule of payments.
Is there any evidence in the record that there was a separate written contract for this purchase and sale? Or were all of the terms, was it purely oral? Were the terms only contained in the deed itself?
It's only contained in the deed, Your Honor. There was no purchase and sale agreement that I'm aware of signed by the parties. It was certainly
the findings. Excuse me. The findings by the judge are really in the what's termed the verdict slip. Is that correct?
That's correct. That's correct.
And the verdict slip was created or agreed to by the parties?
That's correct.
Okay.
This is under the Superior Court rule that permits waiver of detailed findings.
That's correct.
So looking at I know you challenged some of the findings on the verdict slip as clearly erroneous. I understand your challenge as to findings 15 and 16 regarding whether the quitclaim deed included words of limitation. But as to finding 10, the finding, he found that the quitclaim deed referenced in question 1 did not convey to Kimberly Lim all of the legal rights of Keith Soar that existed at the time of the conveyance. I understand that a quitclaim deed conveys all of the rights in the subject land, but it seems that Mr. Soar also had the right to recover $40,000 from Ms. Lim in the future. And you would agree that the quitclaim deed didn't give up that right?
Absolutely.
Correct? Okay,
correct.
So a literal reading of finding 10 would make it correct.
That's correct. That's correct.
Yeah. Is that is the error that you allege or have argued in that finding essential to your case here?
Yes, it is. Mr. Soar has a remedy in law in connection with this matter to. If he had to, he could have sued my clients for the $40,000, but of course they had offered it to him. We've offered it to him on numerous occasions.
Well, maybe I wasn't clear. Is the error in finding 10 that you allege? I thought you just acknowledged that it wasn't actually an error because the quitclaim deed didn't convey the right that Mr. Soar had to recover an additional $40,000.
That's correct.
Okay, but is that essential to your argument? Or if we agreed with you that findings 15 and 16 were erroneous, would that suffice to get you a reversal?
It's not critical. The fact that Mr. Soar is entitled to collect the $40,000 is not critical to my argument, if that's what you're asking. Is that what you're asking?
Essentially, yes. So we could say finding 10 was not clearly erroneous. Nevertheless, findings 15 and 16 were, just hypothetically, and therefore we're reversing.
That's right.
There was no explicit language or sufficiently clear language.
Right. There are other other side issues here. One is, of course, time is, the time is of the essence issue. The fact that payment wasn't necessarily made on time wouldn't necessarily be significant if there's no language in the document that states that time is of the essence. The appeals court in the Olympus case, which dealt with a purchase and sale agreement, stated if there's no language that specifically states that time is of the essence, performance on the date specified is not ordinarily deemed to be of the essence unless it is made so by express stipulation of the parties or is to be implied from the circumstances. And here, again, Mr. Soar was in bankruptcy. My client made the payment late. They didn't know exactly what to do. And that's basically what happened. He's been offered the payment,
yeah. If we were to reverse, what's your client's position on whether Mr. Soar is still able to recover that $40,000?
That he would get the $40,000, of course.
So he's not time barred or otherwise has waived the.
Absolutely not. I mean, that $40,000 has been offered on numerous occasions, and he just refused to accept it. And in the meantime, now we have a situation where the property is uninsurable because nobody knows exactly who owns the property. The judge entered a finding. The defendant in this case, Ms. Lim, conveyed the property to a third party, a corporation that was not. Excuse me?
But it's a corporation she controls, right?
That's correct. But that corporation was not a party to this case because the corporation was in Chapter 11 bankruptcy. So the corporation still has a claim to the property.
But the transfer to the corporation was after the second payment was due, correct?
That's correct. That's correct. It was, but a judgment was entered. The property is now uninsurable because nobody knows exactly what the status of the title is. That's obviously that's a problem as well. So we're looking to reverse the decision. We're saying this is a deed in fee simple, where obviously Mr. Soar is entitled to collect his money, and that would be the way this case should be resolved. And that's what we're looking to do.
Would he have the option were he to have brought suit to say, you breached our agreement and I just want to own my property?
Well, that's what he's done.
Right, and I guess I'm trying to understand why he can't do that.
Because, the argument is that this is a deed fee simple, so my client owns the property. There's no right of reverter here, or it's not a fee simple determinable. If the court finds that the deed is a fee simple determinable, and the court finds that the failure to make the second payment causes the automatic reverter of the property to the seller, then obviously the seller would then own the property. But it's our argument that that's not the case here. That the second payment was not made on time would not be the explicit condition that would require a reversion of the property to the seller.
Is there any difference between a fee simple determinable and a fee simple with the condition subsequent? Is that the same?
I believe that the difference with a fee simple, I'm not 100% sure on that one, but I think the fee simple with the condition subsequent would be that the seller would be required to and make entry to the property, but I'm not 100% sure on that. In this case, based on the judge's decision, it appears that the seller wouldn't even have to do anything to say he owned the property, because the judge essentially said that the property belonged to Mr. Soar, so therefore he didn't have to make entry or even file suit. So the interpretation of the deed would create a serious problem for, again, for title examination.
I'm looking at finding 18, which says whether the conveyance referenced in question 13 was a fraudulent conveyance. 13
Doesn't reference it.
Doesn't reference it. I guess in addition to being confused about which conveyance finding 18 is about, I'm wondering, why does it matter whether some conveyance other than the one at issue here was fraudulent?
No,
And
I'm sorry.
You don't challenge finding 18, do you?
The conveyance reference to it was for less. Well, I do. I challenge the fact that the conveyance, the original conveyance to my client, was made for $80,000. $40,000 was paid. So the answer would be she did not. That Mr. Soar did not receive the full amount, but he was offered the full amount of money. He refused to accept it, and that's why this case ensued.
But is the judge saying in finding 18 that the conveyance that we're talking about now from Soar to Lim was for less than full consideration because she never paid the extra 40 and therefore was fraudulent?
He may. That doesn't make sense to me, but that's. I think that might be a mistake in maybe typing. I think he was talking about probably the second conveyance from Miss Lim to her corporation, but
yes. And why would that affect whether that was fraudulent? Why would that affect whether there's the failure to pay the 40,000?
I don't think it would at all. I don't think it would at all.
Let me just ask you a question about what's the status of the mortgage?
The mortgage right now, the balance of the existing mortgage is about $800,000. The property has been appraised. This was for approximately $150,000 at this point. It's an abandoned warehouse that's not in good shape. That mortgage will be probably drawn down and worked out through bankruptcy if we can get the bankruptcy court involved again. Right now, the corporation that Miss Lim was involved in is no longer in bankruptcy, but we could refile and reduce the mortgage because the balance is the mortgage is significantly higher than the value of the property. And there's been no discussion with the bank at this point, but they haven't pursued anything and they haven't really done anything at this point.
Does anybody have any further questions? Thank you very much for your argument. The case is submitted. And
all right, thank you.
I also just want to thank our staff for all their hard work to keep us going.